Good afternoon, and welcome to the latest rapid response webinar from the section of Civil Rights and Social Justice. Today's program is co-sponsored by the Commission on Immigration, the Center for Children in the Law, and the Criminal Justice sections of the ABA. During the 2017-18 bar year, it's our goal to rapidly respond to government actions that may impact civil rights and civil liberties by offering free webinars, commentary, social media posts, and other information from our subject matter experts. You can check out the rest of our programs and the recordings on our section's website, www.americanbar.org/CRSJ, or check out our Twitter handle at @ABA_CRSJ for more information and replays. During today's program, if you're so inclined, you can ask questions of our panelists by finding the questions box on the right-hand side panel and typing in your questions to us. We've also included 3 handouts in the handout tab of the right-hand panel, which we will also share in a follow-up email, along with a link to other resources. We will also share a recording of this program to everyone who has registered. Hold on one second, we're having a little bit of a technical difficulty. And so I am going to make myself, here we go. Sorry about that. We'll be sending a recording of the program to everyone who's registered so that you can share it widely with your networks. We're thrilled to bring you today's program on Trump's policy for separating families at the border, U.S. law, court rulings, and administration policy. And our legal experts have a lot to say on the subject. I'd like to welcome Prudence Beglokar, Director of ABA Center on Children in the Law and formerly of the Department of Homeland Security Office of General Counsel. We will be joined almost immediately, as Professor Gilman just arrived, Denise Gilman, who's the clinical professor and director of the Immigration Clinic at the University of Texas at Austin School of Law. And Meredith Linsky, director of the ABA Commission on Immigration, will moderate today as well as kick us off. So Meredith, if you could start us off, I'll give it to you.
Thank you, Paula, and good afternoon, everyone. Thank you so much for joining us. We know that there's a lot of interest on this topic for very good reasons. Over the last 2 months, we've seen a flood of media coverage from the southwest border, documenting in vivid detail the traumatic and shocking effects of the administration's family separation policy. The coverage has resulted in public outrage and protests from almost every sector of society, including, of course, the legal community, members of Congress, religious leaders, pediatricians, psychologists, child advocates, movie stars, and private citizens. During my presentation today, I plan to give some background on the administration's family separation policy and then hand it over to my esteemed colleagues Prudence and Denise to discuss the legal implications and consequences of this alarming policy, as well as to discuss 2 major developments on the legal front, the preliminary injunction that was issued on Tuesday of this week, and the lawsuit filed by 17 states challenging this policy earlier in the week as well. As you all know, in April, Attorney General Sessions announced a zero-tolerance policy. This policy was meant to punish and deter migrants who entered the United States without authorization by prosecuting them criminally for immigration-related crimes. Mostly this is illegal entry, under 8 U.S.C. 1325A, a misdemeanor with a maximum 6-month sentence for which most people serve only a few days. Others are prosecuted for illegal re-entry under 8 U.S.C. 1326, a felony. This policy was meant to apply to anyone who entered the U.S. unlawfully, including parents of small children and asylum seekers. By selecting to apply this policy to parents, the government claimed they had no choice but to separate the children to allow prosecution of the adults, thereby rendering them unaccompanied children and placing them in the care of the Office of Refugee Resettlement. Reports show that approximately 2,500 children were taken from their parents during the implementation of this policy, usually while still being processed in Customs and Border Protection facilities. An unaccompanied child is defined under 6 U.S.C. 279 G2 as an individual under the age of 18 who lacks immigration status in the U.S. and who does not have a parent or legal guardian living in the U.S. available or willing to provide care and physical custody. It is important to note that the government has been rendering these children who entered the United States clearly, usually with a parent, and rendering them unaccompanied to pursue this prosecution. Unaccompanied children, on the other hand, have statutorily protected rights under the Trafficking Victims Protection Reauthorization Act, which includes the right to a removal hearing before an immigration judge pursuant to the Immigration and Nationality Act at INA Section 240. ORR is also required to provide representation to this population to the greatest extent practicable. For parents, on the other hand, they're immediately given expedited removal orders under the Immigration and Nationality Act, Section 235. And unless they express an intention to apply for asylum or claim fear of persecution, they're expeditiously removed from the country and barred from returning for 5 years. Through this expedited proceeding, some of these parents have been removed without their children. Because of the extraordinary level of violence in Central America, many of those subject to expedited removal do express fear and are referred for a credible fear interview before the asylum office. But some have given up their right to pursue asylum to be reunited with their children and removed. Meanwhile, DOJ and DHS implemented the policy without any clear guidelines or procedures or systems to keep track of these children and maintain communication between detained parents and detained children, making it very difficult for children to direct their lawyers on how to proceed in their removal cases. Family separation is nothing new. It has been happening for years in isolated cases. The difference in the spring was that it became a public, systematic policy that was intended as an example to deter others from making a similar journey. It is important to recognize that in fiscal year 17, Customs and Border Protection documented the lowest level of unauthorized cross-border migration on record. While overall migration is down, CBP reports that between October 2017 and May 2018, around 32,000 unaccompanied children and 59,000 individuals and family units were apprehended at the southwest border. Meanwhile, on June 20th, after weeks of forceful and sustained bipartisan criticism, including a powerful opinion piece in the Washington Post from former First Lady Laura Bush, President Trump signed an executive order allegedly ending the practice. The executive order represented a qualified repeal of the policy that would only apply to prospective cases, but did not establish a system for the reunification of those children already separated from their parents, unless and until the parent was scheduled for removal, which clearly has a coercive effect on those who fear return but remain separated from their children. The order reaffirmed the administration's commitment to rigorously enforce the immigration laws and articulated a shift towards prolonged family detention, recognizing certain limitations in the law and, of course, resources. It also instructed the Attorney General to file a motion to amend the Flores Settlement Agreement to permit long-term detention of families during the pendency of criminal and immigration proceedings. The 1997 Flores Settlement Agreement set out a nationwide policy for the detention, release, and treatment of minors in then INS custody, Immigration and Naturalization Service custody. In 2016, the Ninth Circuit upheld a lower court ruling confirming that the agreement applies not only to unaccompanied children, but also children held with their parents in ICE custody. The government's motion to amend the Flores settlement was filed on June 21st in the Central District of California. In the executive order, the administration made clear they will continue to separate parents from children when there is a concern that the detention of the child with his parent would pose a risk to the child's welfare, a highly subjective and indeterminate standard. The aftermath of the executive order has resulted in chaos and confusion with no clear path forward. On June 23, 2018, DHS issued a fact sheet that attempted to clarify the government's efforts in reunifying these two populations. It claimed DHS and HHS has a process to ensure family members know the location of their children and have regular communication, and to ensure that those who are subject to removal are reunited with their children for purposes of removal. This made clear that the government will not be reunifying detained parents with their children unless they are removed or somehow get out of detention. The memo explained that CBP had reunited 522 unaccompanied children with their parents, presumably children who remained in CBP facilities while the parents were being prosecuted. The memo also stated that as of June 20th, HHS had 2,053 separated children still in their custody. Overall, HHS detains around 10,000 children on any given day. It has become clear that there will be no attempt to reunify these separated families if the parents remain detained pursuing an asylum claim. When ABA President Hilary Bass traveled to the Rio Grande Valley on Tuesday of this week, she spoke to several women detained at the Port Isabel Detention Center who still had no idea where their children were being held and wanted nothing more to be reunited with them, even if it meant giving up their asylum claims, which is a serious concern for due process and the rights of asylum seekers. Fortunately, on June 26, the Federal District Court Dana Sabra in San Diego issued a class-wide preliminary injunction halting the separation of families unless there is a finding that the parent is unfit or presents a danger to the child, enjoining the removal of any class members without their children, and ordering reunification of children with their parents under 5 within 14 days and all other children within 30 days. The developments are coming fast and furious. I will now turn the webinar over to Prudence, who will speak about child welfare principles and how they apply in this situation.
Great. Thank you, Meredith. That was a fantastic overview of sort of where we are today, and especially I piggyback on the comment that things are moving very quickly, and so we're really happy to have the opportunity to talk to everybody today and recognize that by tomorrow there may be even more new developments. So a lot has happened this week. I want to take a step back and build on 2 points that Meredith raised that I think will provide a really good shape to what I'm going to talk about right now, which is one point, which is the administration and many officials within the administration saying that this was the law and there was no choice but to impose this policy on children and families. And the other is really a question about sort of the transition from this being a practice that was already happening and was being challenged in certain circumstances, but the shift to it becoming an actual recognized and in some ways celebrated policy of the administration that was very openly talked about, because those are really 2 very important pieces of the legal analysis. I will also say, sort of, just as someone who's at the ABA right now and someone who I love being a lawyer in general, but I do want to commend everyone out there in the legal community right now, because I think that this has been something that there's a lot of moral objection, but the truth is that there's also a lot of really, really problematic legal analysis happening. And so I think that this has been an opportunity for those of us in the legal community to really take a stand and make sure that we're providing not just sort of a moral reaction to some of what's happening, but I really commend a lot of the attorneys who are litigating these cases, and attorneys, I should say, as well, because I think it's true both within and outside of the government who are struggling with how to address these issues. So I'm going to talk about from the perspective of sort of children's law, which is primarily rooted in child welfare legal principles, how that has really played a huge role in providing a basis for challenging some of this practice, both at the sort of the policy level and then also now continuing to challenge even after the executive order that came out on the 20th. A lot of child welfare principles have really continued to provide the basis for challenging how the law can be unwound from the need for reunification, and also to prevent further separations and further damage. So from sort of that overarching perspective of the children's law field, there are 2 categories of sort of analysis looking at the impact of this policy and the ongoing impact. To be clear, one category is the right to family integrity. So recognizing that both children and parents have a right to family integrity. It is a right that the Supreme Court has looked at again and again and again and has clarified even in relatively recent years. The Supreme Court has specifically spoken about, for example, parental rights in the care, custody, and control of their children. Those are some of the most fundamental liberty interests of any individuals in the country, and the Supreme Court has recognized that there's 80 years of jurisprudence that support that a parent's right to the care of their child is one of the most fundamental liberty interests in this country. I should say, for the purposes of understanding sort of what those constitutional rights and fundamental liberty interests mean, they do apply equally to immigrant families as well as to citizen and other status families here. And so that is also a very clear area of the law, is that these rights apply to immigrant families as well. And so within that sort of broad rubric of family integrity, that's one category, and I'll talk in a little bit more detail about that. And then the other major sort of challenge from a legal perspective of the children's law field is that this action, both when taken to separate children from their parents and the ongoing separation and failure to reunify, has caused actual harm to children and has put children in harm's way. And I think that's a really important point to underscore, because on the one hand, family integrity is a really important right, and there are very strict limitations on when the government can interfere with that right. On the other hand, putting children deliberately in harm's way is something that a number of different litigants have raised, and a number of the opposition letters raised, and I think is another legal basis on which this is a very frightening thing to have seen take place. So within the family integrity category, there are sort of two types of ways that the government traditionally may interfere with the right to family integrity. One is an intentional interference, which is sort of the basis of child welfare law. So a situation where the government, usually state government, has determined that a parent is unfit to care for the child, or the child is at an imminent risk of harm, and there are safety reasons that require the government's intervention into that family relationship in order to preserve the safety and protect the safety of a child or children. And there are some really, really stringent procedural due process requirements that go along with that determination. And so the sort of concept of intentional interference with intentional governmental interference with parents' rights is something that the Supreme Court has specifically said, you know, and I'll quote, is perhaps one of the oldest fundamental liberty interests recognized by this court, and should only be interfered with in extreme circumstances, but also only when there are specific procedural due process protections in place, including a judicial determination of fitness. The other, which is the incidental governmental interference with the right to family integrity, is something that arises all the time, right? That's something that if a child's parent is arrested in a lawful arrest, that child may no longer be able to be with the parent. There is a sort of collateral or incidental interference with the family being together because of the criminal arrest. This has come up in the context of immigration enforcement, which is not criminal traditionally, but in the context of immigration enforcement, there was a case in the First Circuit in 2007 that addressed a challenge of individuals who had been arrested in a worksite raid by ICE, and who, as a result of that arrest, were not able to care for their children, and they challenged that arrest on a number of grounds, but also on a right to family integrity ground. And the First Circuit specifically held that it was an acceptable collateral consequence in that instance that parents had been separated from their children, but provided some really compelling language clarifying that in that instance there was nothing deliberate about the separation, and there was it was very much a collateral consequence, and it was not something that had been an intentional result of the worksite raid. And the reason that I raise that is because it's really important to have language like that out there when all of a sudden what we had here, going back to some of the points that Meredith raised, is an actual policy where the government openly stated repeatedly through multiple different outlets and multiple different individuals within leadership positions of government stated that family separation was a known and expected outcome of implementing this policy, and that it was very far from a collateral consequence. It was actually openly discussed as a deterrent. So the goal was, through the zero tolerance policy, to have parents who present at the border or across at a non-port of entry, to have parents who come here with children separated from their children as part of a deterrence to discourage parents from coming here seeking asylum. And that's a really different kind of situation than what was condoned in Aguilar, where it was, again, a worksite raid, where as a result of that raid, children were not able to be taken care of by their families. And so what we have here, and what we had in the policy, and we're continuing to see play out in its unfortunate continuing circumstances, is a situation where the government deliberately sort of used intentional family separation, intentional interference with the right to family integrity under the cover of incidental interference, as though doing it as part of a prosecution would make it okay, even though the explicit goal was in part to deter and to separate children from their families. There is no court that has ever condoned deliberate separation of children from their parents as a tool that can be used to deter immigration. And in fact, the courts that have looked at sort of parallel cases, including, there was a case, I know Denise has a lot of institutional background on as well, but there was a case in the DC District Court several years ago that specifically enjoined the Obama administration from using family detention as a deterrent. So in that instance, the administration had detained individuals from Central America, typically mothers, who came with their children, typically seeking asylum, and the administration chose to detain them in order to deter other families from coming. And the court specifically held that civil detention in immigration is for the purpose of detaining individuals when there is a flight risk, or when there is a fear that that individual could pose a safety risk to the community, and it is not acceptable as a deterrent, and certainly not acceptable as a deterrent to discourage mothers and children from Central America from presenting at the border. And so that's one sort of area of law where it wasn't specifically separation, but the courts have already looked at the impact of using these kinds of enforcement mechanisms for deterring populations of immigrants who are seeking refuge here. And then, very notably, in the Ms. L case, that was the motion to dismiss was denied in a case before the Southern District of California just a couple of weeks ago, when the policy, the zero tolerance policy, and the impact on family separation was still very live before the EO, the executive order. In that case, which challenged two incidences of family separation that predated the formal acknowledgement of this policy, a judge in that case denied the motion to dismiss and specifically looked at the facts of those two instances, but also looked at that point at the fact that there was an openly recognized policy and that this was being used as a deterrent. And that judge ruled that the motion to dismiss was denied, the government's motion to dismiss was denied, and that this practice of deliberately separating children from their parents while the parents are held in immigration detention shocks the conscience. That's the language that was used, is that it shocks the conscience and violates, and this was directly in the order, violates the right to family integrity. So we have seen that, on the one hand, there's definitely no court that has ever condoned the use of criminal law enforcement as a cover for intentionally separating children from their families. And there's no court that's ever condoned the use of family separation for a deterrent purpose. And we already have seen several courts that have really made clear that those are boundaries that may not be crossed and that do violate the right to family integrity. The second piece of that, as I mentioned before, is the fact that this action by the government has actually caused harm to children. Is an area that at least I know the states that just filed, I know Meredith mentioned that there's a lawsuit filed by 17 states in the country challenging both the initial practice and the ongoing repercussions of this practice of separation. that they have actually alleged harm from the government's actions in separating children from their parents, and that in and of itself may provide a separate basis in addition to the violation of the right to family integrity. The fact that that the government has taken action that knowingly causes this level of harm to children is extremely concerning. And I think that's where a lot of the really powerful statements from the American Academy of Pediatrics and so many other psychologists and other organizations, even if part of the basis of those statements is to really sort of shepherd some of the moral reaction and address the medical implications of this policy, I think that there's also some legal ground for challenging the fact that this action has actually not only violated rights, but has actually done harm to individuals. And then, so that's sort of trying to tackle the one piece of what made this different, that it was so openly acknowledged as an intentional practice and as an intentional outcome, really did put this in a different legal, in sort of different legal territory than it had been when it was a little bit, it was recognized that there were several cases that were happening and that were being challenged, thankfully. But the open acknowledgement of the intentionality and the use of separation as a deterrent really did put this in a even more solid legal ground as far as the violation of the rights at issue. And then the second piece that Meredith had touched on was that the statements that there was no choice and that this was somehow required by law was something that I think was really proven very disingenuous when the executive order issued, because it was clear that this was not some kind of congressionally mandated action. It certainly was not anything, deliberate family separation was not something that had ever been a policy before. So it was very confusing to understand what that meant, that it was required by law. But I did want to unpack that for just a second, because I think it provides a good segue probably to some of what Denise will talk about as well. There were several members of Trump's cabinet who indicated that this was needed under the law, in part because of the Flores settlement agreement that Meredith talked about a moment ago. And there were sort of 2 points that they suggested, that it was either required by sort of statute or that it was created by the Flores settlement and subsequent case law interpreting that settlement, court decisions. And I just want to clarify that both of those suggestions are very incorrect, right? So there's no law in this country, and I think the U.S. attorneys came out with a very powerful statement, and also many attorney generals from across the country came out with very powerful statements that there was no law, there never has been any law that requires the separation of children from their parents at the border, whether at a port of entry or otherwise. There is no law that requires that. And that certainly, as I mentioned, was clear when the president signed an executive order purporting to end this practice. One thing that I think is an important point to raise on that issue is that not only is there no law that requires this, but actually in the 1990s, when the Supreme Court originally handled the Flores decision, which pertains to unaccompanied minors, there is language in there. It's a Justice Scalia decision, and there is language in there where Justice Scalia specifically talks about how immigration and ensuring that minors who arrive at our borders as immigrants, he specifically talked about how that's a much easier situation when those individuals, when those minors arrive with their parents. And it's Justice Scalia who says, that it's actually a much better situation when children arrive here with their parents, because those families can be kept together and released together. And that's a really interesting, again, there's no law in the books that requires separation, and there is law in the Supreme Court, in the words of Justice Scalia, that specifically clarify that children can be kept and should be kept with their parents and should be released with their parents. And so there's also no law, just to clarify, there's no federal law that requires the Department of Justice to criminally prosecute individuals who come here. It is, as Meredith mentioned, a misdemeanor, and there has always historically been a tremendous amount of discretion for U.S. attorneys' offices to determine when it does and doesn't make sense to do prosecution, to use the resources needed for prosecuting unlawful entry. And this was one respect in which I think the U.S. Attorney's letter in opposition to the policy was particularly powerful as well, because they clarified that the only real collateral consequence of this policy was that it actually took a tremendous amount of resources away from serious crimes and from the ability of those offices to prosecute serious crimes. But just to be clear, there is no law that requires criminal prosecution of unlawful entry in all instances. And then that second piece of the sort of administration's focus on saying that this was legally required, I think really derived from recent court decisions interpreting the Flores settlement agreement. And as Meredith described, that's a settlement agreement that applies both to unaccompanied minors and also to accompanied minors who are held in federal custody. And one of the things that changed was that several years ago, the Ninth Circuit ruled that accompanied minors need to be released just as unaccompanied minors need to be released as expeditiously as possible from federal custody. And they clarified that the Flores settlement agreement does not apply to parents who are with those accompanied minors. And I think that the Trump administration's interpretation of that is that they have a requirement to release accompanied minors, but they are obligated to continue to maintain custody of parents, and that in some way is its own form of separation. And I want to be clear that that's also not required, that although the Ninth Circuit ruled that the Flores settlement applies to accompanied minors and that those accompanied minors have a right to expeditious release, it does not mean that the parents have to be maintained in federal custody. There is no requirement that the parents cannot also be released. They're just not required to be released, but there's no requirement of separation that arises from that interpretation of the settlement. So that's sort of in a nutshell, and I'll just give a quick summary of those points, which is really that the that this policy and the ongoing issues that are continuing to create incredible harm for children as individuals and for parents who are here trying to find their children really does appear to violate not only children and parents' rights to family integrity, but also raises significant questions about the harm that the government has done to individual children in direct contravention at a minimum of state laws and practices related to protecting the best interests of our minor citizens. And that in this instance, the intentionality of the government's action is particularly troubling in knowing that harm was going to be incurred. And I'll pass it to you, Denise, to talk about sort of the next steps and certainly how all of that legal background, I think, continues to carry forward very much with the litigation that we've seen in the past week.
Yes, thank you so much. And you were absolutely right that segues very well into what I was gonna plan to say. And both of you, thank you, Meredith and Prudence, for really laying out the backdrop for all of this with such amazing clarity. And thank you to the ABA for putting this panel together so quickly. That really is remarkable given the extent to which things are changing so very quickly. And at the same time, a recognition of the critical importance of getting well thought out information out there, because there have been so many efforts to confuse and complicate the situation beyond what is actually necessary under the law. So I want to start with a couple of kind of big picture framing thoughts too. And the first one picks up on something that Prudence mentioned and that is raised in the Supreme Court decision in the Flores case, which is that in many ways, families present an easier situation than unaccompanied children. It makes some sense that when an unaccompanied child, a child truly on his or her own, reaches the US border, that the government cannot simply take that child's name down and then release the child into the United States because there has to be concern for what will happen to that child. Now, there may be things that we would want to do differently about the current regime for unaccompanied minors to ensure that it moves as quickly as possible for children to, in fact, be released to relatives or others who can host them. But it's fair to say that there is, in fact, a challenge there about immediate release. With families, you really don't have that challenge because families are a self-contained unit. Where the caretaker is there available with the child, and in fact has generally shown every effort in the case of asylum seekers to protect and care for that child to the very best degree possible. And so it's absolutely possible for families to be processed at the border, information to be taken, information to be provided to the family, and then for that family to be released with notice that they will be appearing in immigration court for further proceedings on their asylum claim. And in fact, the studies that have been done show that when families of asylum seekers are provided with adequate information and where necessary case support, they will in fact appear for those proceedings, particularly if they are able to access legal representation, although even without that, that there are strong incentives for those families to appear. But yet, although the unaccompanied minor situation in many ways is more difficult or requires more government intervention, practice has really been, certainly in this latest scenario, but really dating back to the ramp up of family detention again in 2014, after an early ramp up of family detention in 2006. The actual actions taken by a series of administrations have been actions that make the families a target of much more intrusive measures, including deprivation of liberty, all the way up to, as you're seeing in recent months, active efforts to separate and keep separate families. And so I think we should really think about that in terms of how we would expect our government as a legal matter and as a moral matter to treat families when the same challenges that may be presented by unaccompanied minors just are not presented by those families. And then the second big picture framing that I want to suggest is that the family separation policy of this administration has been very much justified or founded on a premise of, well, the law is the law, and the government is just trying to enforce the immigration laws, and particularly the criminal laws relating to unlawful border crossings, which are, as has been mentioned already, just a misdemeanor. But the government then cannot pick and choose which law to follow. If the law is the law, then all of the law applies. And that includes the law that says that individuals fleeing persecution in their home countries have a right to seek asylum in the United States, whether they present at a port of entry or whether they cross into the United States. It is explicitly set out in the law that Congress passed based on our international refugee obligations under the UN Refugee Convention. That is the law. It is also the law, as Prudence mentioned, that detention cannot be used as a deterrent. It cannot be punitive in the immigration context. This is civil detention. And so it cannot be used to hold people to try to affect the actions of some other family down the line who's facing threats and harm in their home in Central America, because that is a punitive concept that is not allowed in the civil immigration detention context. It is also the law, as we've mentioned today, that under the Flores settlement, children should be released from detention as quickly as possible, generally within 5 days. Under interpretations of the Flores settlement in the family context, they should be released within 20 days. But at the same time, as has been mentioned, the Constitution provides another important norm of law, which is that families should stay together. So if you put all of those laws together, all of those norms that are fundamental norms together, they stand up for the proposition that children must be released and they must remain with their parents. And so the parents must be released from detention, and that detention, and they cannot be held either separately or together as a deterrent to others, because they are not being punished in the civil immigration detention context. And in the misdemeanor crime context, family separation or long-term detention could never be seen as an appropriate proportional punishment. And they must be released because that is the only way to ensure that they really have the right to seek asylum, and that they are not deterred also from pushing forward on their asylum claim. So if the law is the law, it should be all of the law, including fundamental constitutional principles, and not just the misdemeanor criminal law without regard to its consequences, or maybe with an intention of separation as a consequence that goes far beyond it and that doesn't acknowledge the other norms in place. So I thought it might also be helpful to just give you a bit of a sample of how this looks on the ground as I get into what's going to happen with the rulings going forward. So I handled a case of a woman from El Salvador who has given permission to speak about the generalities of her case. And she was detained at the border right after crossing, and after immediately seeking asylum and turning herself over to Border Patrol, along with her 4-year-old and 10-year-old sons back in March. So it was right before the official zero tolerance policy, but we were already seeing a ramp up of these cases. The 2 boys were sent to a unaccompanied minors detention facility shelter under the Office of Refugee Resettlement, which is what normally happens with true unaccompanied minors, although in this case they were made unaccompanied by the separation from their mother. At one point, those 2 boys were held in were separated not only from their mother, but from each other, and put into 2 separate foster homes. They were eventually reunited in the unaccompanied minors facility, and it took about a month for them to be released to other relatives out on the East Coast. Meanwhile, Mom was not prosecuted in this case, although under the zero tolerance policy as it was originally playing out, she would have been if it had been in April. But even then, if she had been prosecuted, it would have looked pretty similar. She would have been held for about a day or 2 at the Border Patrol facility in connection with that criminal case until she went into a federal court and pled guilty on the criminal charge and got time served. And then she would have been returned to immigration detention. And then what happened to her, in fact, would have happened, which is that she was sent to an adult immigration detention center in Laredo, Texas. And she stayed in that adult detention center for 2.5 months. And during the whole time that she was in the adult detention center and the kids were still in the ORR shelter in the government's custody, she could not speak to them at all, despite efforts and efforts and efforts and calls to try to just talk to her little boys. Once they were released to family, she was able to speak to them, but only with great difficulty while she was in detention because she was detained. And it's incredibly difficult to make phone calls. Nobody can call you within an adult immigration detention center. It was incredibly challenging. What was happening with her case while she was detained for 2.5 months in this adult detention center? First, she had to go through this screening interview, this credible fear interview, which Meredith mentioned. And if she did not pass that, she would have been immediately deported. We managed to get her through that stage, although it took exceedingly long. And then once she passed through that stage, then and only then is she even eligible under current interpretation of the law for release from immigration detention on bond or on other conditions. However, in this case, ICE, Immigration and Customs Enforcement, said that they did not wish to release her. And it really did seem to be that in significant part, it was an active determination that because this was a family separation case, she should remain detained so that the separation could be maintained. That was the actual intention of the proceeding. We, of course, took the case to immigration court, which she was entitled to have a hearing on the custody determination in the immigration court. And at that immigration court bond hearing, ICE again pushed the consideration that she should be treated as a flight risk because she had crossed the border without authorization, even though that again is permissible as a way of seeking asylum. And they otherwise argued that she should remain detained. The judge seemed to consider that the fact that release would facilitate family reunification as a negative, and issued a $12,500 bond, which typically would have meant that the family would not have been able to pay and she would not have been released from detention. And so family reunification would have been altogether prevented. In this case, because there has been such an amazing community outpouring to try to seek family reunification, the community raised that bond for her and she was released and she is now reunited with her children. But that is the kind of difficulty that I expect to see even with the preliminary injunction in place as of a day and a half ago, essentially, and we'll see how that plays out. So I think there are two questions about how the preliminary injunction will affect things going forward. So first, as mentioned, is that preliminary injunction is in the case that raises family separation as a violation of constitutional right to family integrity. And the preliminary injunction is, of course, a preliminary ruling, but does find that it is likely that in the end that claim would be successful of a violation of the family integrity. And so the injunction orders the immediate reunification of families. But there are two questions really that come out of it. One is, how are those reunifications going to take place? And second, what does it mean about family detention? Is the alternative just going to be that rather than separating families, they are held long-term in family detention? On the first point, it is not yet clear, despite the preliminary injunction's clear mandate that families must be reunited within 14 or 30 days, whether or how that will impact the kind of scenario that I just described with my client, where you have the parent in adult immigration detention, which is absolutely what the judge was seeing in issuing this order. So the order, it seems to me, should mandate that those parents be released immediately so that they can reunite with their children, regardless of whether they have undergone a credible fear interview and received a favorable finding, and regardless of whether ICE has set their release on recognizance, or whether an immigration judge could be, a hearing could take place before an immigration judge. From what we're hearing from the government, it is not at all clear that that is how they are interpreting the order. So there may well be some additional dispute about how that takes place. It appears that the government seems to be suggesting that they will happily reunify so long as it's reunification for deportation, as Meredith mentioned, or so long as the adult has managed to make their way through that very convoluted process of credible fear and bond, and is then now available, which is incredibly difficult to do without legal representation, and just takes time. As I say, 2.5 months in the case of the mom that I represented. The second question, as I say, is whether what the case means is just that families will remain together in family detention centers. As many of you may know, there are over 3,000 detention beds for families in Texas at the current moment, and about another 100 in Berks, Pennsylvania, or Berks facility in Pennsylvania. And the expectation is that the government may well attempt to keep families long-term in those family detention centers, as was the practice back in 2014 and early 2015 before litigation, the RILR case that Prudence mentioned, the Flores case that we've all been talking about. And I can tell you from experience working with family detention that while nothing is worse than family separation, family detention for prolonged periods is only slightly better. It is truly horrific and problematic as well. And in fact, the ABA, Commission on Immigration, did a lengthy report on family detention that I was involved in back in 2015 that is worth recovering and looking at right now because it is so troubling. I certainly hope that the issue will be framed as we have been framing it today, as one in which that long-term family detention is not proper, because while it may get out of the family separation constitutional violation, it does not comply with other norms in play, including the Flores obligation that children be released and that they be released from detention preferentially to parents who also have their own right not to be detained in an across-the-board manner, and particularly not for deterrent purposes, because this is civil detention. Other litigation on the horizon that will impact all of this. Of course, the Flores case itself, as Meredith mentioned, the government has now filed a motion to amend the Flores settlement, essentially to get around that existing interpretation and norm that says that children must be released very, very promptly, and usually in the family detention context, no later than 20 days into their detention. I don't actually think that the motion to amend the Flores settlement is very likely to succeed. It was tried back in 2014 by the Obama administration when family detention ramped up at that time on very similar arguments that the border has changed in recent years, and that there are larger numbers of families arriving and that it's difficult for the government to manage it. The court rejected that argument at that time, and should reject it now. It's important to know in this context that while it is true that there have been larger numbers of families and unaccompanied children arriving at the border seeking asylum, given the very, very grave human rights situation in El Salvador, Honduras, and Guatemala, where murder rates are among the highest in the world, overall border crossings are at historic lows, truly dramatic historic lows. We are talking about in 2000, you had 1.6 million unlawful border crossers. In 2014, during the last crisis, and we're in similar numbers now, you had under 400,000 unlawful irregular border crossers, and of those a very high percentage are families and children who present no threat and simply just must be processed on their asylum claims. So I don't think there is likely to be a Flores modification. I do worry, though, that there will be strong efforts to interpret Flores to require only the release of the children and not to require release of the parents, and so that is where it becomes so critical to bring together the litigation on family separation and the litigation on the right of a child to be released, so that it's clear that families must be released together. And I hope that that litigation will come together in Flores. There's been a very interesting development in the Flores litigation just in the last day as well, which is that public counsel and the law firm of Sidley Austin have filed a motion to intervene on behalf of the parents to make these very points about the rights of the parents to remain with their children as the children are released, and to invoke their own rights to be released from detention unless they present a flight risk or danger as well. And so we'll see that litigation become critically important. There has been also, as has been mentioned, litigation now by 17 states also challenging the harmful impacts of family separation. And so that may also kind of triangle the litigation so that it is read together to require release of families, given the important role that parents play in caring for their children and helping them to overcome the harm that they have suffered as a result of separation. And then there have been a number of sort of more individual private actions being filed too, and others being considered, seeking to just obtain reunification of particular families, but those cases may be important because they may really put the rubber to the road in terms of how this reunification has to happen in individual cases. And they may also either end up being or invite additional claims for monetary damages, which may well be appropriate given the harm that has taken place, and may kind of create accountability for the administration's actions on these cases, on the family separation. I'm mostly going to end there. I do just want to echo in one final point, because we've been talking about existing norms and litigation and what we can expect in the courts going forward. I do want to echo one point that Prudence made, which is that there is no law that requires family separation or long-term family detention or family detention at all. And so the calls for congressional action are probably best understood as being calls for policies that would penalize or harm family detention. There is very little positive that could be expected at this particular moment by congressional action. And so I think it's important to keep that in mind as well, because there is no law currently that requires any of these negative policies. Thank you.
I'd like to make one point that I think we have not made yet today, and that is that the Attorney General has suggested that one justification for zero tolerance is the fact that there is a proper way to apply for asylum in the United States, and that's by going to the U.S. Port of Entry and requesting asylum. And that is disingenuous in many ways because, one, in Ms. L.V. Ice, the case that was filed recently, the plaintiff there was separated from her daughter, although she did come to the port of entry seeking asylum. This is a mother from Congo with her young daughter. And also because we have heard many experiences of asylum seekers coming to the border and being turned around, being told that there is no longer asylum in the US, or there's no capacity to interview them at that time and to come back at a later time. Meanwhile, they're in very dangerous areas of the southern border in northern Mexico, where drug cartels control all of the areas on the northern border, and they're waiting for days or weeks at a time with young children on the ports of entry. So that's another point to raise.
Can I, Meredith, actually, thank you for that. And can I just chime in and confirm that while that practice of turning people around at the border had happened sporadically in Texas and Arizona in the past and was happening pretty much across the board in California where people were having to wait, at the exact same time that we were seeing the ramp up of zero tolerance and separation, we were seeing, including in Texas along all the areas, all the ports of entry, that people were being told either that they had to wait or simply that they could not enter the asylum process at ports of entry. And I do just want to add, for those who aren't as immersed as we are in the asylum world, that another kind of misperception or point that has been made frequently out there is the idea that people should have applied for asylum in their home countries. And I want to make very, very clear that that is just simply not an option under asylum and refugee law, that you must make your way to the United States to seek asylum. The possibility of refugee resettlement from abroad, first of all, requires that you be outside of your home country to apply. And second, really does not apply for Central America, where most of these refugees are coming from. There was a very, very tiny pilot program that allowed for certain Central American children to apply from within their home country or within the region to come to the United States as refugees. And that program was canceled almost immediately after the inauguration of this administration. So it simply is not possible to apply for asylum or refugee status of any kind from within the home country in Central America.
I did want to raise the recent AG decision in matter of AB and ask Denise or Prudence, either one of you, how that decision is going to impact these cases, if it is.
Denise, I'm happy to have you take the lead on that.
Okay. So we're very concerned about the impact. And for those who don't know, the decision of matter of AB overturns a 2014 precedential decision that had been well-founded and well-observed law for the last 4 years that recognized domestic violence as a viable grounds for asylum. Just recently, in matter of AB, the Attorney General took upon himself a decision which, under current interpretation of the immigration statutes, he is allowed to do, and issued a precedent decision that overturned that 2014 case allowing domestic violence asylum claims, and used the decision that he issued in matter of AB to call into question other kinds of Central American asylum claims, including gang-based claims that are often formulated as persecution on account of family membership and the like. We're very concerned about the impact of that decision in general, but particularly in this context of family separation and family detention, because there is an explicit footnote in the decision that directs the asylum office, which adjudicates these credible fear screening interviews that determine whether a person will even have a chance to present their asylum claim and whether they'll have a chance to get released from detention. That footnote directs the asylum office to essentially generally deny domestic violence or gang-based claims. Now, we have not heard that the asylum office has actually fully taken up or accepted that charge, and as well they shouldn't, because they are in the Department of Homeland Security, not the Department of Justice, and they are charged separately with interpreting the asylum statutes. But it's very clear that there is a strong message of trying to foreclose Central American claims. And if that message is heard well at the screening stage, the credible fear stage, it will mean that families, separated parents, will be deported without a chance even to pursue their claims in immigration court to asylum and to reunify with their children. And we do expect that we are seeing lower grant rates in that threshold screening interview, even though the asylum office hasn't fully taken to heart the AG's decision in matter of AB.
Do you want to walk us through a denial of a credible fear interview? I know that there is a review available in immigration court, but it's limited. Do you want to talk about that a little bit?
Sure. I mean, that's exactly right. So as you described, Meredith, very aptly, the way the process works is somebody at the border who's apprehended, whether presenting at a port of entry and knocking at the door and saying they're seeking asylum, or crossing in, to even get a chance to present their claim in immigration court, they have to pass this credible fear screening interview, and they must be detained until they pass it. And the asylum office conducts the initial asylum office screening interview, credible fear interview. It's a very short interview. It's often conducted for adults in detention by telephone. That's what happens for women asylum seekers near me, with an interpreter on the phone and an asylum officer on the phone, and the asylum seeker doesn't know if they're talking to somebody from their own government or what is happening. They certainly don't know that ARCG and matter of AB put limits on and criteria on how they need to present their claim. If the asylum officer does not grant credible fear and allow the case to go forward on asylum and immigration court, then there is a very limited review from within detention with the immigration court. Many of the immigration judges that we are seeing are essentially just rubber stamping whatever the asylum office said, maybe asking a few additional questions, very limited review. And then if you do not pass at either of those stages, you are deported.
There's no judicial review, correct?
No judicial review of any kind.
Prudence, I wanted to ask you a question about how parents' rights in the general child welfare system apply to the situation with separated families. Can you talk about that a little bit?
Sure. So it's a good question because it's still relevant, right? And so I want to just emphasize that even though some of those constitutional concerns that were flagged, and certainly that we laid out in the ABA letter to Attorney General Sessions and to DHS Secretary Nielsen, were relevant to the separation, the zero tolerance policy and the separation component of that. A lot of these problems are still very much, these constitutional violations are still very much present. And so traditionally, in the context of parents who have been separated, and this is very relevant for the purposes of both the reunification right now, and also for the purposes of preventing any future separations, that there are specific requirements that a court with jurisdiction to make determinations about child welfare and about parental fitness make those determinations. There are really, really clear procedural due process requirements about parental fitness determinations and safety determinations with respect to that child before the government can separate children from their parents. And the reason that that's really relevant in the ongoing litigation is that, you know, everyone in the injunctive relief that's been requested has been doing a carve out for, you know, children cannot be separated from their parents unless there's been a fitness determination. And this was also in the EO, in the executive order, with respect to sort of that family separation can't occur unless it's, I can't remember the exact language, but unless it's, you know, for the child's welfare. And I just want to be clear that that kind of really general language is not sufficient, that there are, first of all, the federal government does not have jurisdiction to be making fitness determinations for the purpose of child welfare and government authorized separation. That's a state court determination. And the second is that there are required procedural protections in place to protect those due process interests. In many jurisdictions, both children and their parents have a right to counsel for those determinations. Almost everywhere, parents have a right to counsel for those determinations. And like I said, in most jurisdictions, children also have a right to representation in child welfare adjudications before state courts. And so with respect to the requested relief in a lot of these cases that are still pending, the language that I personally thought was the most, that was perhaps the most accurate in terms of recognizing those due process and procedural protections was the injunctive relief sought in the Washington state litigation, which specifically says that it has to be a decision. The order, I'm just looking at it right now, they order reunification between all children who've been separated from their parents. They order reunification unless a court of competent jurisdiction has found the parents to be unfit, and competent jurisdiction would be a court in a state law, like a state court that has jurisdiction to handle those cases, and presumably the parents and in most instances the children would be entitled to representation in those proceedings. So that carve out, although it's in the injunctive relief and although it's in the EO, it's not really a broad carve out, and you can't have like a CBP officer or an ICE officer making a fitness determination. You can't even have you know, the federal government at any level making a fitness determination for the purposes of sanctioned separation between children and parents.
Thank you, Prudence, and thank you, Denise. I want to ask one question here. I mean, many people are asking us, what can they do? Many people across the country are concerned about what's happening. They'd like to contribute to an effort to help reunify children, to help represent children or parents. And I want to talk a little bit about that with the both of you. I do want to express that the ABA has a border project called ProBar, the South Texas Pro Bono Asylum Representation Project in Harlingen, Texas. The ABA also sponsors a border project in San Diego called the Immigration Justice Project. Both of those projects represent parents who have been separated from their children. ProBar especially has been on the front lines of providing legal services to detained adults, children, and separated families in the Rio Grande Valley for 29 years now. They are seeking lawyers fluent in Spanish, preferably who have a background in immigration law, to represent detained parents in their asylum proceedings. As you can imagine, it's very difficult to represent young children in these proceedings when they're often very concerned about what's happening with their parent, what is their parent deciding to do, whether they're going to fight an asylum case or request removal or accept removal. And when they can't communicate, it's become a great challenge. So if you are interested in going to ProBar and you have those skills, I would suggest you reach out to their outreach director, Emily Joyner. We can provide her email address. You can also reach out to me, Meredith Linsky at AmericanBar.org. We also have a project in Houston called the Children's Immigration Law Academy. They provide training and technical assistance on unaccompanied children's cases. Their website is www.cilacademy.org, and you're welcome to go on there to get training, CLEs, and attend in-person trainings as well. The ABA president, Hillary Bass, has been very vocal in opposing these separations and raising a lot of the legal arguments that we've discussed today, and why this policy is problematic, not only on a moral level, but also on a constitutional level, and because of many of the laws that exist and how they violate those laws. So I would suggest that we will provide a link to some of the letters and some of the articles that have gone out in the American Bar Association Journal that you can read and have suggestions for further action. Finally, I'd like to say that the Office of Refugee Resettlement recently made a decision to cut funding for cases of children who have been reunified throughout the United States. And so that may be somewhere where you'd like to volunteer or provide a donation with children who have been reunified. They're reunified all over the country, but some of the major cities are Houston, Los Angeles, New York, Miami, Chicago, and help a child go through a removal proceeding, because really it's virtually impossible for someone to do it alone. Even more difficult for a child. So Denise, Prudence, I don't know if you have any other suggestions.
That was incredibly helpful. I would certainly put in a pitch for both ProBar, the organization that Meredith mentioned that's through the ABA that operates down in South Texas, because that really is, even according to the executive order, kind of ground zero right now for the parents who've been separated. And there are still hundreds of separated parents there who are fighting to avoid deportation, ideally get released from detention, and absolutely get reunified with their children. So that need is very immediate, although they do probably need mainly people with at least some expertise or who can take a mentor along and a translator. But I would also put in the pitch for the organizations that are all around the country, because when these families are released or when kids are released, they also need representation. And it is actually quite challenging to find the representation in the locations where they're going, even in some of the major cities. So please do train up, or if you already have the training, volunteer your time to represent kids and or families. And that is so critical, in part because they desperately need the representation. Nobody can do this alone, but also because it helps to combat the rhetoric that these are not viable asylum claims, because when you get attorneys on a case, they generally are viable asylum claims, but they're not necessarily claims that an individual can bring on their own. And the empirical information all demonstrates that individuals who have counsel are in the high 90s in terms of percentages of likelihood to appear for their hearings. So we also combat the argument that there's any risk of flight in these cases.
If you're looking for a project in your area that represents immigrants in removal proceedings, you can go onto the ABA ICANN site, Immigrant Child Advocacy Network site, and we can provide you with a referral. There's also the standwithimmigrants.org site where you can sign up to take a case in the area where you live. I think we have a couple of minutes. I don't see any questions right now from the audience, but if someone has a question, please let us know.
From the ABA, we just want to thank the three of you so much for explaining everything and for this fantastic presentation. We're really honored that you were able to do this at such short notice, and so grateful to you guys. So thank you. I will be sending out the recording of the program to all of the registrants. We'll have it on our website, and it can be shared widely with attorneys and non-attorneys and ABA members and non-ABA members alike. So thank you so much again, the three of you, for participating, and thank you to our audience, and I will sign us off.
Thank you.